Welcome to TDS, the Trial Defense Service. I am Major Victoria Bell, and I'll give you an overview of the Enlisted Administration Separation, also known as chapter process. This video will help you understand your basic rights and options. This video can't address every possible question that may apply to your case, but don't worry, at the end of this presentation, you will have the opportunity to speak with an attorney from TDS. TDS attorneys are not in any way affiliated with your chain of command or any other command on the installations where they are located. TDS's only mission is to advise you, the soldier, on what they believe to be in your best interest, without any regard to your chain of command and what they may want. Their services are provided by the Army at no cost to you. You may also hire a civilian lawyer at your own expense if you'd like to. Whatever you discuss with your attorney is confidential. You or your escort must have your original separation packet, as well as a complete copy for you to review prior to meeting with your attorney. That's your right under Army Regulation 635-200. This is a regulation that covers involuntary separation. You must also have your mental and physical evaluations done. If you've not, please notify the paralegal when your name's called. You must also have been notified in writing that your command wants to involuntarily separate you. Please look at your packet and see if your commander's signature is on the memorandum notifying you that the administrative separation process has begun. If it's not signed, please notify the paralegal when your name is called. Separations under AR 635-200 are administrative in nature. They're not considered punishment. It's your command's way to force you to leave the service prior to the end of your current enlistment. There are many reasons that a soldier may be involuntarily separated, or we also call it chaptered. I will not be able to discuss every chapter with you. If administratively separated, you should know that you may receive one of three possible characterizations of service: honorable, general under honorable conditions, or other than honorable, OTH. An honorable discharge is appropriate when the quality of service generally has met the standards of acceptable conduct and performance of duty for Army personnel, or is otherwise so meritorious that any other characterization would be clearly inappropriate. A soldier separated with an honorable discharge will generally be entitled to all Army Veterans Administration or VA and state benefits. This may include GI Bill benefits and educational assistance from the VA. A general discharge is a separation from the Army under honorable conditions. A general discharge may be appropriate if a soldier's military record is satisfactory but not sufficiently meritorious to deserve an honorable discharge. Soldiers who receive a general under honorable conditions discharge characterization may be ineligible for GI Bill benefits. A general discharge characterization, however, does not generally serve as a discharge-related bar to other VA benefits or to the benefits that may be given by the Army or available under state law. An other than honorable, or OTH discharge, is appropriate when the reason for separation is based upon a pattern of behavior that constitutes a significant departure from the conduct expected of soldiers. A soldier separated with an OTH discharge will be deprived of substantially all benefits that may be given by the Army, the VA, and state law. This separation can have a negative impact in both long and short term. The discharge is the most severe you can receive in administrative separation. Please don't confuse an OTH discharge with punitive discharges, including a bad conduct discharge, also known as a BCD, and a dishonorable discharge, also known as a DD, which are only issued by a court-martial. So you may be wondering what rights you have if you want to stay in the Army or obtain a better discharge. Well, that depends on whether you're entitled to an administrative separation board or only have the right to respond directly to your chain of command in person or in writing. Soldiers are entitled to a separation board under two circumstances. You have more than 6 years of combined active or reserve service, or the command recommends that the soldier being separated receive an other than honorable discharge. So now that I've discussed your general rights, we're going to talk about what a separation board is. A separation board is composed of 3 commissioned officers or 2 commissioned officers and a senior non-commissioned officer. Their job is to determine whether or not a factual basis exists for the separation, and if they determine there is a factual basis, then they have to decide whether or not you should be separated from the Army. If they determine you should be separated, then they will decide the type of characterization of your service. If you're entitled to a board, you have some additional decisions to make. First, you have to decide whether or not you want this separation board. If you're satisfied with the potential separation from the service, as well as the proposed characterization of service, or you simply wish to leave as quickly as possible, you may want to waive the board. In addition, even if you decide you want to go to a board, you could waive your personal appearance before the board. If you do this, the board will still meet and make the findings they're required to make, but you just won't be present. However, your attorney may be present. If you decide you want the board and want to personally appear before the board, you may waive representation by an attorney during the board itself. All of these options have consequences that you may not be aware of, so please discuss them with your attorney before electing any of them. If you do decide to waive the board, you can make your waiver conditional in order to receive a higher level of discharge. For example, if your command wants to separate you with an OTH, you can conditionally waive your right to a board provided that your command separates you with an honorable or general. If you decide to waive the board, you can still submit statements to your command. You can make a written personal statement indicating what you think is appropriate for your particular situation. You can also include other evidence such as statements of good duty performance from coworkers, awards, certificates of appreciation, and letters from family or friends. If you have any questions about what you should present, please discuss them with your attorney. Next, we'll discuss your rights if you're not eligible for a board. If your command wants to separate you with a general discharge and you have less than 6 years of service, you unfortunately are not entitled to a board. If you're not entitled to a board, you may submit evidence or information you want your chain of command to consider before they make a final decision on your separation. You can make a personal statement indicating what you think is appropriate for your particular circumstances, and you can include other evidence such as statements of duty performance from your coworkers, awards, certificates of appreciation, and letters from family and friends. Like with the administrative separation boards, if you have any questions about what you should present, please discuss them with the attorney who will be available to you after this video. Before we conclude, there are a few other things to know. First, you are entitled to a copy of your complete packet. You should have your copy now. However, if that copy doesn't have the memos in which your chain of command makes recommendations or the order of the separation authority that directs the separation, please make sure you obtain these prior to your separation. Second, if you're entitled to and request a board, please stay in contact with your attorney. Even though a board is not as formal as a court-martial proceeding, you will still need to prepare thoroughly with your attorney. Also, if you voluntarily absent yourself from the Army, which is what we call AWOL, the command may be able to proceed with the separation in your absence. Please do not leave until the separation process is complete and you fully outprocess the Army. Absence without leave is a crime, and the command can choose to prosecute you at a court-martial when they regain custody of you. Third, if you have unconditionally waived any of your rights, you may withdraw that waiver at any time before the separation authority orders, directs, or approves your separation. Fourth, if you have made an unrestricted report of a sexual assault, please let your paralegal or attorney know about the fact during your interview. Fifth, you have a right to appeal this action to the Army Discharge Review Board or the Army Board for Correction of Military Records. If you think you may want to appeal, please be sure to get your complete separation packet before you are discharged. Please note that there is no such thing as an automatic upgrade of your discharge. Your characterization of discharge will remain in effect unless and until the Army Discharge Review Board or the Army Board for the Correction of Military Records changes it. Sixth, your time in the Army may be coming to an end, but it's not over yet. If you get in trouble now, you can still be punished under the UCMJ and be subject to trial by court-martial. Everyone being processed for separation must have the opportunity to speak with a trial defense service attorney. It's required by the regulation. Please don't leave until you've had that opportunity to do so. The Veterans Administration and the Army Transition Assistance Offices also have information on benefits upon separation. Please consult them, as this information may help you understand what specific benefits you may receive should you ultimately be separated. Thank you for your attention and good luck.